Hello, I'm Amanda Moore, the Director of the Clearinghouse Community. Welcome to our Shriver Hangout for June 2016. Both the Clearinghouse Community and these Hangouts are brought to you by the Sargent Shriver National Center on Poverty Law, a national leader in advancing justice and opportunity. We're glad you could join us for our monthly conversation with advocates advancing change. Today we're speaking with a couple of people who are joining us today from the Bay Area. First we have Saru Jayaraman. She's the co-founder and co-director of Restaurant Opportunity Centers, also known as ROC or ROC-United. And Saru, I think you're joining us today from Oakland?
Yes. Hi.
Welcome. Thanks for being here. And we also have with us Evelyn Rangel-Medina. She's the director of the Bay Area chapter of Restaurant Opportunity Centers. Evelyn, you're in Berkeley, right?
Yes.
Well, thank you for joining us. I should also tell everyone that Evelyn just graduated from law school at Berkeley and is currently in the throes of studying for the California bar exam. So I think I can speak for all of our viewers when I say send you congratulations and sympathies at the same time. But you will get through it. It will end. We're talking today with Saru and Evelyn about their current their work and the article that they wrote, which is our current Clearinghouse article. It's called Advancing a Living Wage and Human Rights for Restaurant Workers in the United States. We're going to be talking about tipped wages and their work to remove this two-tiered wage system that we'll hear more about soon. We would like you to be part of this conversation while we're talking. We would love to hear from you and hear your questions, or if you've been doing work like this, we'd love to hear from you. There are a couple ways you can contribute to the conversation. If you're watching through Google itself, you can hover your mouse over the left side of the screen. You'll see a column of icons pop up. One of those is blue and says Q&A. If you click that, a chat box will open and you can submit written questions to us that way. Don't worry, your face won't appear. We won't hear you. We'll just see your words. If you want to go ahead and test it out now, feel free. You can just send us a quick note to tell us your name and where you're watching. We know that some of you are not watching through Google. You're watching the live stream on the Shriver Center's YouTube channel. We would love to hear from you too. You're welcome to send me an email. I'll be monitoring emails as we talk. My email address is right here below. That's Amanda Moore, M-O-O-R-E, at povertylaw.org. And you can find their article, also listed here, the web address, at povertylaw.org/clearinghouse. All right, well, let's jump in and get started. Saru, I'll start with you. So your article, it describes this two-tiered wage system that most of us are quite familiar with, and that is that some workers earn a set wage and others who are tipped earn a wage that's set below the minimum wage. So, I admit I never really thought much about that. I just sort of assumed tipped workers get tips and that it all shakes out in the end, but that's not necessarily the case. Can you tell us what it is that's problematic about this two-tiered system for wages?
Sure. So I think it's important to start by understanding the context of the industry. The restaurant industry right now is the second largest and absolute fastest growing sector of the U.S. economy. It's over 11 million workers. 1 in 12 Americans currently works in the restaurant industry, and yet it happens to be the absolute lowest paying employer in the United States. So every year the U.S. Department of Labor puts out a list of the 10 lowest paying jobs. Every year we win the award. 7 of the 10 lowest paying jobs are restaurant jobs. And here's the part that most people don't know. Every year 4 of the 7 lowest paying jobs in America are tipped restaurant jobs. So that's even taking tips into account. You're talking about literally the poorest workers in America. And the real origin of this whole idea that workers could earn very little and live on tips is problematic to begin with. So the reason that you've got one of the largest and fastest growing sectors of the economy proliferating the absolute lowest paying jobs is the money, power, and influence of a trade lobby called the National Restaurant Association. We call it the other NRA. And its power dates back over a century, actually, and I would really put it to the emancipation of the slaves, because it turns out that tipping didn't originate in the States. It originated in Europe, in feudal Europe, actually. These were serfs and vassals and domestic workers in aristocratic homes who were always receiving a wage, and a tip was a noblesse oblige, a patronage given to a serf or a domestic worker on top of their wage, never instead of a wage, but always on top of a wage. Well, that idea came to the States in the 1850s and 1860s and was mutated because of our ugly slave history, in that when it came to the States in the 1850s and 1860s, right around the time of emancipation, the restaurant industry and the Pullman Train Company both demanded the right to hire newly freed slaves and not pay them anything at all and let them live on customer tips. And so you see this feudal idea, which Europe eventually rejected as the vestige of the feudal system, was actually mutated and made much worse here in the States because these were mostly black workers at the time who there was a history of not paying them anything at all, and the restaurant industry and the Pullman Train Company successfully argued that that idea should be codified into law. And that is, in fact, what passed in 1938 as part of the New Deal, which said you have the right to the minimum wage, the first minimum wage in our country, either through wages or through tips, which gave tipped workers the right to a wage from their employer of $0 an hour. We went from $0 in 1938 to a whopping $2.13 an hour, the current federal minimum wage for tipped workers in 2016 in the United States. Now it's between $2 and $7 in 43 states in the United States. There are 7 states, of course, that have completely rejected this system, including California, which has the largest and fastest growing restaurant industry in the country. But in these 43 states, the Restaurant Association has argued exactly what you just said. There's no reason to raise this wage. These workers earn a ton of money in tips, and they paint the picture of a white guy working at a fancy fine dining steakhouse, when in fact 70% of tipped workers in America are women. They're disproportionately women of color. They're women whose median wage, including tips, is $8.50 an hour. They're women who suffer from 3 times the poverty rate of the rest of the U.S. workforce, use food stamps at double the rate, experience the worst economic instability because their income from tips fluctuates wildly, and worst of all, suffer from the absolute worst sexual harassment of any industry in the United States, because when you're a woman earning $2 an hour and working at IHOP, which is the kind of restaurant most of these 6 million women work in, you have to tolerate whatever a customer might do to you, however they may touch you or treat you or talk to you, because the customer is always right, because the customer is paying your bills, not the employer. And it's just best summarized by a member of ours from Texas who spoke at a Senate press conference. She said, "Senators, what would it be like for you if your income depended on the happiness of the people you serve?" She said, "Because my income depends on the happiness of the people I serve, I have to put up with a guy groping my butt every day to feed my 4-year-old son at night." These are largely single moms feeding their families on the whims and largesse of customers, which again is disgustingly a vestige of the feudal system and a legacy of slavery.
That's a quite shocking picture, and really does go against what I think most people think of as tipped wages and tipped workers. You and ROC have been working in coalition with some others to start to eliminate this idea of the 2-tiered wage system. Can you tell us about the work that's going on right now across the country to do away with this?
Sure. You know, for many years, I have to admit, we at ROC ourselves were in the wrong place on this issue. We assumed what you just said, that it's fine, these workers earn tips, it's fine for them to get a lower wage. We had just been fighting to raise the tip minimum wage for many, many years, over a decade, from $2 to something higher. When 2013 rolled around, I had a book come out, and 3 things happened that made us realize we were dead wrong. First, we did a lot of research on the 7 states that have completely eliminated the lower wage for tipped workers: California, Oregon, Washington, Nevada, Minnesota, Montana, and Alaska. We did what's called regression analysis. We found that these 7 states are faring better on every measure than the 43 states with lower wages for tipped workers: higher restaurant sales per capita, higher job growth among tipped workers and the industry overall, even higher rates of tipping. People tip better in these 7 states than the 43 states with lower wages for tipped workers. So the idea that tips would disappear if these workers got a wage is just completely not true. So if these 7 states could do it and be more successful, we realized we really should just be following the path of these 7 states and eliminate this lower wage. But the second thing that happened was that Nancy Pelosi came out with her women's economic agenda. She actually invited us to join her on stage at many town hall meetings around the country, and she would get up there and say, "We need to end the fact that women earn 77 cents on the man's dollar." And at the time, we were fighting for legislation that would get tipped workers, who are mostly women, to 70% of the overall minimum wage. So we would get up after her and say, we need to raise the minimum wage for tipped workers, who are mostly women, to 70% of the overall minimum wage, and realize we were essentially fighting for legalized gender pay inequity. But the third and most horrific thing was that just countless stories that came in of sexual harassment and even sexual assault from thousands of women from across the country, and realization that actually, after doing a lot of research, the women in the 43 states with lower wages for tipped workers experience twice the rate of sexual harassment as women in states like California, where they get a full wage and aren't as desperate to actually get a tip from the customer. We also found that women in the 43 states, basically all states except the West Coast and Minnesota, were 3 times as likely to be encouraged by management to dress more sexy, show more cleavage, wear tighter clothing to make that money in tips as women in states like California and the 7 states that have eliminated this lower wage. So for those 3 reasons, we launched a campaign called One Fair Wage, which is calling for the full elimination of the lower wage for tipped workers. Frankly, we had to spend a year, 2013, 2014, really educating our own allies and friends on our side of the table who were raising the minimum wage across the country and leaving the tipped workers out. But finally, in 2014, the AFL-CIO Executive Council at the national level passed the first resolution in its history supporting the full elimination of the lower wage for tipped workers. That was followed by 8 states introducing legislation on the East Coast proposing the full elimination of the lower wage for tipped workers. Congress, Democrats in Congress introduced 3 bills proposing the full elimination of the lower wage for tipped workers. Hillary Clinton has actually come and stood with us and said we need to eliminate the lower wage for tipped workers. The White House has come out in support. And Maine is on track because it has a ballot measure moving for this November. Maine is likely to become the first state on the East Coast in the history of the United States to fully eliminate the lower wage for tipped workers, and many, many states are looking like they will follow. So tons of momentum. I think one of the most exciting things I just want to share to an audience of attorneys is that we've had a bunch of employers, restaurant owners, come out in support of One Fair Wage. In fact, 200 restaurant owners have worked with us to form an alternative restaurant association called RAISE, Restaurants Advancing Industry Standards and Employment. Many of these employers, high-profile restaurant owners like Danny Meyer and Tom Click, our top chef, are saying this 2-tiered wage system doesn't work for us as employers either. Because it creates, showing that restaurants in California have about 1/3 of the litigation rate that restaurants in New York have, because the 2-tiered wage system forces employers to jump through a bunch of hurdles which are necessary to actually enforce a 2-tiered wage system and ensure that there isn't misuse of the lower wage for tipped workers, but hurdles that just wouldn't exist should you just get rid of the lower wage for tipped workers. And so we've actually had, believe it or not, even employer side attorneys from very, very big defense side firms come out publicly calling for the elimination of the lower wage for tipped workers.
Oh, that's really interesting. Evelyn, I'd like to bring you into the conversation. In the article, the 2 of you frame this issue as a human rights violation. In what way does the subminimum tipped wage implicate human rights?
Yes, well, we see that international law provides well-established universal standards for workers that set up a baseline for fair working conditions. And what international law mandates is that wages must be paid directly to workers, which we know doesn't happen under the subminimum wage, largely because in subminimum wage states, it is the customer that's paying for the wages, or that is expected to pay for the majority of the wages of workers. Another thing that international law recognizes and mandates is the equal remuneration of the right to employment benefits and equal treatment with respect to work of equal value, which, again, it doesn't happen under the subminimum wage structure. And the international law frameworks provide an avenue, a more holistic framework for advocates to, one, recognize that the subminimum wage structure violates human rights and labor rights, but also an opportunity to move beyond just setting a minimum wage minimum that doesn't really provide access to a life with dignity and access to a living wage for the majority of workers.
I want to pause here and remind our viewers we would love to hear from you. If you have any questions for Saru or Evelyn, please feel free to submit those through the Q&A app or send an email to amandamoore@povertylaw.org. On the human rights front, at the Clearinghouse, we've published several articles over the past few years. We even had one special issue about this overlap in poverty law and human rights law and how we shouldn't ignore human rights laws domestically. I think in the past we've kind of thought that's for international things and not domestic. So, Evelyn, I'll stay with you for this one. In your mind, what is the benefit of talking about subminimum wage as a human rights violation?
I mean, I think from an advocacy standpoint, when we start recognizing when we start advocating, calling for giving workers access to a living wage instead of just setting a bare minimum, it gives us more space and opportunity to really inject justice into the way that low-wage workers are living into, and also into what's available. Like, one of the things that really calls my attention to the international human rights is the fact that there is a recognized right to health, to housing, food, and family for workers. And I think that we need that holistic framework in order to really advance justice for low-wage workers in the United States.
Many of our viewers are civil legal aid attorneys. That's sort of our core audience for this. Saru, how could they get involved? What do they do if they have a client come in the process of talking with them about something, realize that they are experiencing some of these abuses, or maybe they and their coworkers are upset at the level of wages they're getting, and they're part of this two-tiered wage system? What could a legal aid attorney do in that instance?
Yeah, so there's two ways we think that legal aid attorneys can support this issue. The first is that there is just rampant, I would say, overwhelming non-compliance with the actual laws surrounding the two-tiered wage system. The U.S. Department of Labor actually reports an 84% violation rate. That's known violations, but 84% violation rate with regard to employers actually complying with the two-tiered wage system, actually ensuring that tips make up the difference between the lower minimum wage and the regular minimum wage. So of course, rights, the rights of these workers include, number one, being given notice every time that they're hired or their wage changes, whether up or down, whether there's a raise or a decrease. Again, the employer has the obligation to give notice to the workers. I'm hiring you at less than the minimum wage because tips will make up the difference, and I will ensure that if tips don't make up the difference, that I will pay you the difference. So we see, we've surveyed about 7,000 or 8,000 workers nationally and found one instance in which employers were actually going back and literally counting hour by hour to make sure that tips made up the difference. And frankly, we feel for employers. That's an incredible burden. It's very hard to know. Tips are gray and distributed to lots of workers, which is why it would be better just to get rid of the system. But to that point, the notice issue, what we call topping off, ensuring that tips make up the difference, ensuring that tipped workers are always interacting with customers and not doing a lot of back of the house work. So we're seeing a huge rise in cases as minimum wage goes up of just dumping all the work onto the cheaper workers, onto the tipped workers, having them do everything from clean the bathrooms to fold the napkins. A huge rise in class action lawsuits around this. So these are all things that frankly I don't think most tipped workers even know, that A, they're not supposed to be doing non-customer related work that could earn them tips on the tip minimum wage. B, that employers are supposed to make sure of that difference. C, that they're supposed to get notice every time their wage changes or they get hired. These are all things that legal aid attorneys can educate workers on and help us by actually, every time you hear of these cases, talking to us about it, because we are putting together a national clearinghouse of these cases. Knowing of these cases happening around the country helps us develop legal expertise around them, and much more importantly helps us make the case to get rid of the system. So we have an attorney partner we're working with, Christopher Williams, at the Wage Law Office, and it's actually in Chicago, and Chris is helping to develop this national clearinghouse of cases and expertise on the tip minimum wage, both, again, to help us make the case, also to show employers that, look, this is not working for you. As many employers have already said, there's just too much litigation.
Oh, that's great to know. And I'll remind our viewers that everyone who registered for today's Hangout, so even people who aren't watching, if they registered, will receive a follow-up email with a link to a recording of our conversation and a link to the article. And I'll put a reminder in there about what you just said, Saru, sort of if you see these things, to let you know and put your contact information in there so people can get in touch with you easily. We've had a question come in from Leslie. It's a great question. I'm glad that she brought it up. You've discussed the gender demographics of tipped workers, but I'm wondering, what are the racial demographics? And I think you hinted at this earlier, but if you could talk a little more about the racial justice implications of this two-tiered wage system.
Yeah. I'll start, and Evelyn, if you'd like to add. Tipped workers are disproportionately people of color, and unfortunately, there's real stratification even among tipped workers, that the highest paid tipped workers, the highest tipped workers, tend to be fine dining servers and bartenders, and we've done a ridiculous amount of research to show that those folks are almost exclusively white men. And in fact, we've done what's called match pairs audit testing studies, where we've sent 400 pairs of white and people of color applicants, with the people of color having a better resume, into fine dining restaurants to apply for those coveted server and bartender positions, and found that white people had twice the chance of a person of color of getting one of those jobs, even when the person of color has a better resume. So what does that result in? It results in, even among tipped workers, the very few that the NRA loves to lift up, the Restaurant Association loves to lift up and say, look, they're fine, there's no reason to eliminate the tip minimum wage. That sliver of folks is entirely white people working. Yes, in a fine dining restaurant, you can earn upwards of $100,000 a year in tips in a city like Chicago or the Bay Area. But most tipped workers are not those folks. They're the runners and bussers, who are generally people of color also living on the tip minimum wage. They're the servers in casual restaurants like the Red Lobsters and Olive Gardens, again, disproportionately people of color in those restaurants. And frankly, even among workers, even in the same restaurant, you'll see a white tipped worker, even if they have the same position, earn up to twice as much as the person of color, because beyond all of the stratification that I've already talked about, tipping, if you look at all the studies on tipping, reflects the worst race and gender problems in our country. White servers are tipped at a much higher rate than people of color, even if the person of color provides much better service. Women are only tipped better based on their breast size and their hair color and their eye color and whether they touch the customer. So all of these studies have shown tipping has absolutely nothing to do with service and everything to do with all of the existing isms in our country. And so that, combined with the fact that the people of color are already stratified into lower level positions, results in what we just found in the Bay Area to be a $5 or $6 per hour median wage differential between white workers and and people of color, even just among tipped workers. So the tip minimum wage needs to go not only to get rid of the gender pay gap, but really to get rid of the race wage gap as well.
Yeah, and just to add to that, one of the things that we're working in California is, what does it look like after we eliminate the subminimum wage nationally, and how do we really move the rest of the country into a one wage structure that actually has a ladder, especially for workers who are the most vulnerable. And we do see that the prohibition against race discrimination is a universal human rights norm, and we really want to inject that into the policy that we're moving forward here in California and the Bay Area, because even though we don't have a subminimum wage here, we still see a lot of barriers to promotion and also to employment in higher end restaurants for people of color. And once they're employed, we also want to make sure that they have access to a living wage and that they have access to career ladders, and that they're not necessarily just put into the back of the house, because as we've seen in the restaurant industry nationally, the darker your skin color, the more likely you are to be in the back of the house. And so it is integral to to our advocacy to address racism and discrimination on that end as well.
Well, Leslie, thank you for that great question. I'm really glad we got a chance to highlight that point in our discussion. I'll remind our other viewers we're nearing the end of our time. If you would like to submit a question while we're talking, feel free to do that through the Q&A app in Google or email me at amandamoore@povertylaw.org. You're both attorneys. Evelyn, I'm going to go ahead and say you've got the JD. We're going to count that. But this isn't what we think of as traditional legal services work, the work that you're doing. How does your legal training influence your work to secure living wages for restaurant employees? And Evelyn, I mean, I think I could be wrong with this. Were you doing this work before you started law school? So I'm assuming there was something about the pull of the law that you thought would be an extra tool to help with this. So I'm interested to hear what that is.
Well, I'm following in Saru's footsteps. I'm actually really excited to be able to work next to her and learn from her. But yeah, I did a lot of advocacy and organizing on behalf of people of color, really addressing structures of power and how they impact people who stand at the intersection of multiple vulnerabilities. And I really wanted to go to law school so that I could have more of a command of the way that legal structures intersect to sustain sustain oppression, and also to identify opportunities to alleviate that oppression and dismantle it. And that's why I started working at ROC in my last year of law school, because I wanted to really integrate my understanding of the law into organizing and advocacy. And that's how I really feel that, or what I'm really called to, creating change in that way, and in a way that really brings into the forefront the voices and the experiences of the people who are the most impacted, and at the same time have a bigger, macro policy way of thinking of the world, so that we can have a bigger impact in that way.
And Saru, you're coming at this, I'm asking you this question sort of at not the total other end, but with a few years under your belt. How does your training as an attorney, how does that affect how you approach this work?
Well, it definitely has helped us understand some of the things I've talked about. For example, helped us frame the issue for employers differently, help them think about it as a liability issue. But I think it's interesting, law school does not prepare you to think about how to change the law. It prepares you to think about how to enforce the law. And in some ways, getting that training and that perspective helped me then reject it, essentially, to say it cannot just be about a rights-based system in which we just enforce what exists. We really need to look at, as Evelyn has talked about, a human rights framework, not a civil rights framework, a human rights framework in which we're thinking much more expansively about what's right and just, not just what is the law.
I like that answer. I want to, before we go, I would like to talk just for a couple minutes about ROC-United, about Restaurant Opportunity Centers. It has such an interesting history and has grown so much and is doing such great things. So I know there are books about this organization and its history. So if you can give us the super condensed version, but I would like to give you a chance to tell us about what ROC-United is and briefly how it came to be and what it is now.
Sure. Briefly, we founded the organization just after 9/11, September 11, 2001, with workers who lost their jobs at Windows on the World, which was the restaurant at the top of the World Trade Center, Tower 1. On that morning, 73 workers died and about 250 workers lost their jobs, and we set up a little relief center in the aftermath of the tragedy for the workers, for the displaced workers. But what started as a little relief center for workers has grown into a national organization of now workers, employers, and consumers, all three stakeholders in this industry fighting for better wages and working conditions. We're now in 15 states across the country, and so we've grown geographically, numerically, and also in terms of who our stakeholder base is, and have published lots of books on the industry, done research, opened our own restaurants, train workers, and do this kind of policy work to change the industry.
Great. That was an impressive, quick summary. It's a lot of history in a minute or so there. Well, I want to thank both of you. Our time has come to an end. I want to thank both of you for your time today. This is a fascinating subject, and I think it's not on enough people's radar, so I hope that your article and this Hangout will be able to get a few more people aware of this work and what needs to change. So thanks for being with us today.
Thank you for having us. Thank you.
And I want to thank all of our viewers today. I will encourage you, just a second, there we go, to remember to check out Saru and Evelyn's article, Advancing a Living Wage and Human Rights for Restaurant Workers in the United States. You can find that at povertylaw.org/clearinghouse. If you're interested in this and other topics relating to poverty law, please join our mailing list at povertylaw.org/join. You can also follow the Shriver Center on LinkedIn. And I'd like to encourage you to watch your inbox for details on next month's Hangout. We are still working out those details. It's vacation season, and so sometimes it takes us a little longer than others to find a date that will work. But we will get that secured, and we'll send everyone notice so you can join us next month. Until then, remember that you're not alone out there, and thanks for joining us.
Thank you.
Thank you.